Hello, this is the introductory broadly over chapters 1 and 2 of the Rossmann-Tarr Bill of Rights book. Just real briefly, in terms of this, kind of broadly over chapters 1 and 2, I mentioned in the overview of the class, this course, of course, is obviously over the Bill of Rights, which are technically the first 10 amendments to the U.S. Constitution, and then also the 14th Amendment, because as we'll talk about more, 14th Amendment says no state shall deprive a person of life, liberty, or property without due process, etc. So it specifically applies to the states. So the U.S. Constitution, broadly speaking, sets out the structure of government. So in a Con Law 1 class, we would discuss Articles 1, 2, and 3. Article 1 is Congress, Article 2 is the President, Article 3 is Judicial Branch. Article 4 sets out things like, powers of states, and Article 5 is like, how do you amend the Constitution? Article 6 is the Supremacy Clause. So the Articles 1 through 7 really sort of set out the broad structure of the government in our federal system. The 10th Amendment sets out more about federalism and so-called states' rights amendment, and there are other amendments, of course, up to 27 amendments. This class is only going to deal really with the First Amendment, 2nd, 4th, 5th, 6th, 8th, and 14th for the most part, a little bit of the 9th as well. So we're going to be dealing obviously with Supreme Court cases for the most part in the text of the document itself. Some of the assignments may have to do with Federalist Papers. The Federalist Papers are a series of essays written by James Madison, John Jay, and Alexander Hamilton, mostly Madison and Hamilton. They were written in the 1780s in New York and Virginia newspapers, basically arguing for the ratification of the Constitution. So when the Constitution was written in 1787, it then had to be ratified by the 13 states, or by 9 of the 13 states. And so we don't really have time to go to it much in this class, but there was some pushback in some quarters. So by men like Patrick Henry and a guy named George Mason and some others who were skeptical of a strong federal government and were wanting to sort of limit that government. So the Constitution is the document that basically limits the government by defining its powers and then attempting to define the state's powers in relation to the federal government's powers. Again, that's mostly a Con Law 1 section. One of the other controversies is what this class really deals with is the limits of the government in relationship to the individuals in this country. So free speech, press, bear arms, property, 4th and 5th Amendment, court process, 5th, 6th, 7th, and 8th Amendments as well. So that's mostly what this class deals with. One of the other issues in chapter 1 is the Supreme Court's position. So how do cases get to the Supreme Court? Pretty simple for the most part. You file your lawsuit or your criminal case at the state level or at the federal district court level. Some of you in the TRAD program have taken courts and criminal procedure. I don't have the time to go through the entire federal court system and state court system in this class. But you file your lawsuit, and then you've lost your lawsuit, and then you can appeal that decision to the Ninth Circuit here in California, Court of Appeals. And then if you lose there, you can then at least apply for a petition or a writ of certiorari, as it's called, which is in the book in chapter 1, to appeal to the Supreme Court. If you're in a state court, you can also appeal your decision all the way up to, say, the California Supreme Court. If it deals with a U.S. constitutional issue, then you can also then sometimes go from, say, the California Supreme Court to the U.S. Supreme Court. So later on, when we get especially to the criminal justice chapter, chapter 7, Miranda versus Arizona, Terry versus Ohio. Well, Miranda, right? The Miranda rights, and we'll talk more about that, is an arrest on a state law case, but it dealt with the 5th and the 14th Amendments to the U.S. Constitution, which is how you jump from Arizona to the U.S. Supreme Court in that case. So the U.S. Supreme Court which is what SCOTUS stands for, Supreme Court of the United States, made that decision because they had the jurisdiction to do that. This is all in your first PowerPoint. I'm going to reference specific slides in the PowerPoint. I don't really like to record on PowerPoints because it's hard for me to follow sometimes. So, plus I'm not going to be able to discuss all the slides in every chapter in a relatively brief period of time in 8 weeks. So, yes, there's the picture there on slide 3 of the current Supreme Court. There's 1 Chief Justice and 8 associates. The Chief Justice has no extra authority. He, in this case, John Roberts, is administrator of the court, so he runs the business, the budget, the HR, that kind of stuff. He gets a little extra money. But of the voting, it's 1 of 9. He's got no extra vote. 5 to win, you got to have 5 to win. The rule of 4, 5, sorry, all 5 fingers. The rule of 4 refers to 4 people agree to hear your appeal. So when you appeal a case, you send it to the court. They sit around a table, a literal table, and they decide whether or not to hear your case. It doesn't mean they agree with you. They might want to take it to kill it. But that's called the rule of 4. The Judiciary Act of 1789 is the actual law. So the Supreme Court of the United States is the only court mentioned by name in the Constitution. That's Article 3. It then authorizes Congress to then create courts as needed. So again, long story short, as the country and the population have grown over the decades and centuries now, Congress has created courts to basically meet the need of a growing country and a complex economy and a global economy and all of that. So Judiciary Act of 1789 creates the first federal courts below the U.S. Supreme Court. Starts out by creating the district courts. Judiciary Acts of 1869 sets the Supreme Court at 9. So that number is set by Congress, not by the Constitution. All the Constitution says is there shall be a Supreme Court. Congress is the one that sets the number of the court, and that's been 9 since 1869. 1891, the Judiciary Act of 1891 is where Congress creates the U.S. Circuit Courts of Appeals. Judiciary Act of 1925 is where the Congress creates the Supreme Court building. So if you've ever been to Washington, D.C., the U.S. Supreme Court has a beautiful courthouse and a sort of neoclassical Roman architecture. Think about the columns and all that. Beautiful. And then it also gave the court what it called a, quote, discretionary jurisdiction. So this is all on slide 4. Discretionary docket means that the court can pick and choose its appeals. So again, as the country got north of 150 million people, its caseload was exploding. And so now the Supreme Court only hears those cases it really thinks it needs to hear, which is a relatively few, maybe 70 to 80 cases in a year, right? Maybe more sometimes, maybe less, but about 70, 80, 90 in that range. Federal jurisdiction. Jurisdiction, remember, is the authority of a court. So in federal court, the jurisdiction's pretty broad. And one's called federal questions. Federal question jurisdiction is relatively simple. U.S. Constitution, U.S. laws, U.S. regulations, U.S. signed treaties. So U.S. law, those are federal questions. And then what's called diversity jurisdiction, there's outlined lawsuits between citizens of different states. So if you live here in California and you get in an accident in Nevada, you have 2 choices. You can sue them in Nevada, in a Nevada state court, if that's where your accident occurred, or you could sue them in federal district court in Nevada, federal court, not a state court, if your damages are more than $75,000. And then you can also sue citizens of foreign states. So if you're driving along the 5 and you get hit by someone with Jalisco plates, you can sue that person in California court if you think they'll show up for trial, or you can sue them in federal court also. That's called diversity jurisdiction. Now, moving ahead to slide 6, what are the powers of the court? Now, we live in an age, and you guys have all grown up in an age where we look at the Supreme Court as this all-powerful, super powerful branch. and it wasn't really drawn up that way. It's relatively sparse, Article 3 in the Constitution. Anyway, Federalist 78, Alexander Hamilton calls the judicial branch the weakest also. And its inherent powers, inherent means part of it. Like if you say court, what is assumed? So the founders would have assumed these basic powers of a court. One is mandamus. Mandamus is to basically force government officials to do their legally obligated duties. Contempt of court is to maintain order in the court, basically, so punishing people who misbehave, who don't do their jobs, who lie. A writ is a court order that enforces a ruling, so arrest warrant, search warrant, jury summons, those kinds of things. Habeas corpus is a writ where a court can take someone out of jail or prison and determine whether or not they're supposed to be there. So we see that in a variety of ways. If you think about arraignments and first appearances, bail hearings, there's all sorts of things that are sort of part of the right of habeas corpus. And then the last one there, adjudication. Adjudication just means to judge between two litigants. That's the core function of a court, is adjudication. Marbury versus Madison. Marbury versus Madison is, for our purposes in this class, and again, this is a case we would talk a lot more about in a first version of constitutional law. But Marbury versus Madison basically sets the stage for what we call judicial review. It is the first case in 1803 that establishes the power of the Supreme Court or any federal court to review the acts of government officials. In this case, James Madison, Secretary of State. And nowadays, you think about lawsuits against acts by President Obama or Biden or Trump, and going all the way back to, Andrew Jackson, etc. That's called judicial review. It also can declare acts of Congress and states unconstitutional. So if Congress passes a law that is against the Constitution, the Supreme Court can strike that down. And so in slide 9 is really the kind of the money quote here. Justice John Marshall writes, "It's emphatically the province and duty of the judicial department to say, quote, what the law is." So courts don't make law, right? Courts interpret law. So as he says in the next line, those who apply the rule to particular cases must of necessity, right? They have to expound and interpret that rule, right? You have a body of text. You would think it would be straightforward. Sometimes it is, and sometimes it's not, right? And the facts don't always fit the law. So judges are interpreting. If two laws conflict with each other, and sometimes they do because humans are not perfect, the courts then must decide on how each of those laws operate. And so in Marbury versus Madison, they do that. So Marbury is basically suing for a job that he should have been given by Thomas Jefferson, the president. Madison is his Secretary of State, should have given him this job. This kind of supplements what's written in the text, so you need to read the text for sort of the full story. And so the Supreme Court basically dismisses the suit, saying Jefferson should have given him his job. So the court says, we could tell you and make you do this, but this guy, Marbury, didn't follow the right procedures. So Jefferson, you're wrong, but you win because we don't have authority here. The other thing they did is they declared this section of Section 13 of the Judiciary Act of 1789. So not all the law, but one section which created and gave the Supreme Court jurisdiction, which it does not have and can't do. In other words, the Supreme Court, because it's the only court mentioned in the Constitution spells out the Supreme Court's jurisdiction, and Congress cannot amend the Constitution, right? There is a way to amend the Constitution, and it is not by statute. There is a process in the 5th article of the Constitution. And so they struck down that law of the Constitution. So if you look at slide 11, there's the bolded part of Section 13 at the bottom that shows you the part that is, there. And then I've given you some of the language there as well. Slide 13 gets into Chapter 2. Chapter 2 talks about interpretation and constitutional legal interpretation. Again, we talk a lot about that. um, in modern age. And so, all branches interpret the government, so interpret the Constitution. The president does, Congress does, the court, of course, does. So I wouldn't say any president has the right. They do have the right to interpret the Constitution. Anytime they do something, they're interpreting the Constitution to some degree. We as citizens interpret the Constitution, right? As persons in the United States. And so interpretation, the two basic kinds here. One is, I would put the two lines there. So this is slide 15. Original intent / and then textualist. Those are kind of the same thing. So original intent and textualism basically adhere to the text that is on the page. What does that mean? And they would just say, it means what it says, right? When it says due process, well, obviously you can stretch out what is process. So if you think about due process, well, what is that? Well, process would be what? It would be an arrest warrant, probable cause. It would mean a first appearance, an arraignment, a bail hearing, hiring a lawyer, having a trial, having rules of evidence and rules of procedure. Due just means what is owed me as a person in the United States, right? No person shall be deprived of life, liberty, and property without due process. So, what is life? Life is pretty simple, quite frankly. People can muddy up those waters, but science is clear. Life begins at conception and it ends when you die. We might argue about some of the timing of those things, but that's pretty clear. The government can't take your life without due process, right? Property, liberty, that's really the one we're going to argue a lot or talk a lot about this semester. If you think about liberty in terms of speech, press, religion, to bear arms, to be secure in your house and your stuff, your cars, etc. And then the other basic argument is what's called a living constitution. And that's more where they're not interested so much in the words on the paper, but in sort of what are called holdings, the outcomes of cases. So they're like, okay, generally speaking, this is what we want, and how do we get there? So there's dangers inherent in both of the approaches if you're extreme, I think, on either one. But those are the two basic sides, that the idea is the Constitution is freestanding, meaning it doesn't matter that it was written in 1789. This is 2026, and we need to apply it this way. There's some dangers in that as well. So positive document, positive there doesn't mean like, yes, awesome. Positive there means basically it's kind of a scientific thing, and it can be changed from the outside without reference to anything prior, meaning with no reference to history, the founders, the framers, the way that the culture was when they wrote it, what did it mean to them, etc. So that's a whole semester course just on that one issue. Here's an example that's actually before the Supreme Court. This the so-called birthright citizenship, right? So here's 14th Amendment. This is slide 16 on the packet. All persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and of the state wherein they reside. Now, the 14th Amendment was written after the Civil War, specifically to deal with the issue of freed slaves, most of whom by this point were born in the United States, in the states in which they were at that time slaves, and of course now they are freed persons legally. There were still people, of course, born in Africa or born in the Caribbean who had been imported and sold into the United States. But for the most part, born or naturalized. Naturalized means they've lived here a long time, even though they were born somewhere else. So basically, the Constitution is trying to solve the issue of freed slaves, African Americans, right? But the amendment says nothing about slaves. It says nothing about black people. It says nothing about Africans or etc. It just talks about persons in the United States. Well, it's 1868. What else is coming on? Irish are coming in. Chinese and Japanese are coming in on the West Coast. We have Mexicans coming in from the South. Obviously, you have Indians, some of whom are living on reservations, some of whom are living in cities. You have Greeks and Germans and Italians and others coming into the United States in the late 19th century. So the plain reading, at least in my mind, is if you're born in the United States, you're a citizen. Right now, the case will be about a different interpretation, which means if you're not a citizen here, then the kid you have here is also not a citizen. But that's where this sort of original intent versus living constitution kind of comes in. Slide 17, you see the word there, stare decisis. Stare decisis means let the decision stand. For the most part, courts will abide by earlier decisions, but not always. Sometimes they overrule cases. So, for example, the Dobbs case that came down in 21 overruled Roe versus Wade vis-a-vis abortions and whether all states have to provide or allow for abortions or not. Brown versus Board of Education overruled Plessy versus Ferguson. Plessy versus Ferguson said that that as long as facilities are equal, they can be segregated based on race. Brown versus Board of Education says, no, that's not right. It's not constitutional. It's also morally wrong. And so therefore, we have integrated schools and integrated public spaces, et cetera, et cetera. By law, it's illegal to discriminate based on race. The 14th Amendment always said that, quite frankly. Plessy versus Ferguson, which was an 8-1 decision by the Supreme Court and wrongly decided. Nevertheless, that was a precedent that the court followed until they overruled themselves in 1954. Here, slide 18, mostly uniformity to deal with that. Lawyers, for the most part, are relatively conservative creatures. I don't mean that politically necessarily, but meaning or judges rather, they don't like a lot of change. People to do business, to order their lives, need some stability, and the law is designed to provide some stability. That doesn't mean it's moral necessarily, because, slavery was legal for over 100 years. That was stable, but it was also evil, right? Jim Crow was the law for over almost 100 years. That was stable, but it was also evil. So just because something's stable doesn't make it right. But on balance, things that are non-chaotic and and that are stable and orderly tend to allow for flourishing. That's the idea anyway. And then checks on the court. So that's 19 and 20 and 21 and 22. So checks refers to checks and balances. Again, that's something more for basic constitutional court. I will say that the Bill of Rights does act as a check on state and federal governments vis-a-vis individuals. So you have sort of multiple checks and balances in our constitutional order. One is the branches checking each other. So we're going to see the court acting as a check on the government, other branches of government, when they violate the First, Second, Fourth, Fifth, etc. amendments. But then the other question is, who watches the court? Like, okay, who checks the court? Well, we've already talked about that one. One is Congress. Congress has checked the court by jurisdictional legislation, right? They created courts. They can destroy courts. They gave the courts jurisdiction. They can limit the court's jurisdiction. Article 3, it sets out when things can come to the court. So it says case or controversy. In other words, you can't go to court for a dispute unless there's, quote, a case, which means two litigants, or a controversy, which means they don't agree with each other. So just in that very language, the Constitution limits the courts by saying you can't hear issues unless there's an actual case, meaning somebody's been injured. That's what that means in the law. And two, the parties don't agree. That's a controversy. That's what the V is in court. Roe versus Wade. Roe and Wade are against each other. Smith versus Jones, right? That's what the V. V means versus. And so ripeness means that you have to actually wait to be harmed. Mootness means the issue's been resolved. So the issue is moot, meaning case dismissed. There's no issue here. Courts don't issue advisory opinions. They don't give legal advice. That's what lawyers are for. And then standing means you have to sue on your own behalf. So you're all adults, I'm assuming, over 18, and so therefore you have standing to sue on your own behalf. If you own a company, you can sue on behalf of your company, but you can't sue on behalf of your friend or your neighbor or your adult, siblings, generally speaking. And then the last one here, slide 22, Judicial restraint is the idea that judges that I said, are sort of conservative, little c, not politically necessarily. They don't generally like a lot of change. Now, I mentioned external checks on the court. So judicial restraint is an internal check, meaning the judge, him or herself. What are their personal views about the law and the court? External, so Congress, Chisholm versus Georgia and the 11th Amendment. Again, we won't talk about that much in this class, but the Congress can amend the Constitution. And in that case, they didn't like the opinion of the court. They overruled them by changing the Constitution in the 11th Amendment. Impeachment, if judges run afoul of the law, they take bribes, are corrupt, commit crimes, the Congress can remove federal judges through impeachment. Jurisdiction legislation, Congress can change the jurisdiction of courts. Obviously, the president in executive appointments has some say over who's on the court. And then one of the internal is what are called political question doctrine. So the court generally will not get involved in military and foreign policy issues. So no one can sue. I shouldn't say no one can sue, but if they were to sue, say, hey, we shouldn't be fighting in Iran or Venezuela or Iraq or Afghanistan or whatever, the court's going to dismiss that and go, that's not our job. Our job is not to do that. Now, if there's something illegal going on in that concept, so a defense contractor is taking a bribe or a soldier is murdering civilians, then a federal court might, on appeal, be able to hear that case. State politics, generally they won't get involved there as well unless someone's First Amendment rights are being violated. And then non-justiciable issues refers to things that courts just can't deal with. So the main one there would be like, say, religious dispute. I don't know if any of you are Catholic, but if you're a Catholic, then it's called transubstantiation, right? They believe that the Eucharist, the elements of the Lord's Supper for you Baptists, become the actual body and blood of Jesus Christ in the Mass during the Eucharist. That's a theological issue. The court has no business, for one, deciding that issue. So if a church split over that issue or got in a knockdown drag out over whether there's a Trinity or a unity, three-person God versus one-person God, or who's better, Jehovah or Allah or whatever, and the court's not going to get involved in that. They're not geared towards that. It's not a legal issue. So that's called a non-justiciable issue. So anyway, that's a little bit more than I wanted to put in. It's 27 minutes, but that's chapters 1 and 2 in overview, basically.